Welcome, everybody. This is the latest episode of JuristAI Litigates. I'm Ali. I'm here with JuristAI's Chief Legal Officer, Mark Underwood. And today we're going to take a look at two cases in particular, but also their broader impacts on American society. So we're going to be looking at the case of Mahmoud Khalil, who was and still is a Palestinian advocate and activist who was a student at a prestigious university that has had his visa revoked and is currently in detention awaiting possible deportation, but is fighting his case out in court. And Rumeysa Ozturk, who had written an op-ed for her university's newspaper and then was also detained for her student visa to be revoked. She was a graduate student going for her PhD. So we'll be looking at some of the constitutional ramifications and some of the immigration law that goes into this. And of course, we have our seasoned legal expert here, Mark. Just to remind you, what JuristAI does is we make research tools and litigation lifecycle software for attorneys and for the public. And so we'll be using our software here to kind of analyze these cases and help us get a better understanding of what's going on. So with that, I will give a short background to each one of these cases, and then we will get into it with Mark's legal analysis. Let me just kind of share the screen. So this is Mahmoud's case on our platform, Litigates, which is right here. You can find it at litigateai.org. So Mahmoud was involved in quite a few protests at Columbia University. He was also involved in the encampments. They just recently released a documentary about that. It was pretty rambunctious over the summer. There were some interactions between police and the protesters. Quite a few protesters got arrested. And Mahmoud Khalil was one of the main agitators and activists for these protests. And I think we're all pretty familiar and aware that American universities and campuses have always been a site for political advocacy going back from the Vietnam War and even before that. So Mahmoud Khalil was on a student visa in Columbia University. I believe he actually is originally Palestinian. So if he gets deported, he will be going back to one of the Palestinian territories. I'm not sure exactly where they would send him to, considering the ongoing war. But his visa, the Trump administration is trying to revoke his visa and basically argued that he supported terrorism with his protests, and therefore, although he did not commit a crime, he no longer has a right to be in the United States. He had a green card. The other case, which is Ozturk versus Hyde, these are the filings in the case here, is a Turkish national pursuing a PhD at Tufts University. And she submitted an op-ed at the Tufts University paper. The government got wind of it, and she was very famously arrested on the street. I think most people have seen the footage of that, but I can definitely pull it up. So before I pull that footage up, Mark, what are your initial thoughts?
Well, I think this is all, and let me take a step back just to let everyone know what you just showed everyone was LitigateAI's access to PACER, which is the federal repository for cases that are litigated in federal district, federal appellate, and the Supreme Court. And those are all accessible through LitigateAI. If you subscribe to LitigateAI, you are able to pull up these cases, be able to get a summary of those cases, be able to understand context based on those cases. And if you are a pro se or an attorney who is representing litigants in the federal courts, this is a great way for you to have access to PACER because that's part of our access and subscription. And then secondarily, it's way better than PACER because PACER, if you use it or have access to it, pro se litigants can't get to it because they can't get a subscription. And then secondarily, there are a lot of per page charges that are part of PACER. That's part of what you get with your subscription with LitigateAI. That said, I think what we're seeing is, and I don't know if anyone or everyone is aware, but this week, the Supreme Court supported the decision to allow the current administration to use something called the Alien Enemies Act of 1798, which is a wartime law that hadn't been used since World War II. What
Wow.
that says is that if you can be declared, even with constitutional provisions in place for the First Amendment and with the constitutional right to counsel, etc., you can be disciplined by being detained without counsel and deported without hearing based on this act. And so the Supreme Court supported this in a 5-4 decision this week. It requires that deportees be given a reasonable time to challenge the removal, but as we've seen in the news lately, that's not happening. The administration has, in fact, defied court rulings and deported people who actually had status as citizens, not just green card holders. So that said, the first thought that I have is in both of these cases, we historically in the United States have supported the First Amendment in many, many ways. And to your point earlier, Ali, universities have been sort of the place where young people who are intelligent, bright, aware, want to have the world know what the challenges are currently that they're concerned about, and they use the First Amendment to go out and protest peacefully, to go out and do things that are protected fully to communicate their positions, especially on campuses. And so it's challenging to have them, as in the case of the first gentleman that you talked about, be called an agitator because he's using his First Amendment right to be heard and to rally peacefully. And then it gets out of hand, someone gets arrested, and then they go back to the person who started the movement, started the discussions, started the rally, and then he's now in the position where he could be deported. And then taking it to the next case where this young woman did an op-ed piece uh, to her university paper because the administration didn't like her approach to it, having her be removed in the similar fashion seems ludicrous, but then having the Supreme Court sort of uphold this in the short term, it's troubling because as I mentioned to you, I took the same oath to protect and defend the Constitution of the United States that every elected official does. And so I think a lot of lawyers are troubled by this, and I think immigration attorneys have an opportunity to approach this in a way that's meaningful if we can all get together and figure out how to utilize it. So I think you brought up what's happened here and how I think this is ice that we've
Yeah,
determined is.
this is the ice and plain clothes. So that's Miss Ozturk. What's really interesting as we see her, so from what I read, she actually just thought that she was being harassed or abducted. She didn't realize that these were government officials because they are plainclothes dressed. So I think
They're not dressed like government officials
yeah,
at all. They have masks on, they have dark clothing on.
yeah,
This is not.
they look like a gang.
Yeah.
So that's what she thought was happening. I think she was actually on the phone, so she was trying to call somebody. So while we're watching her get arrested, which is definitely a disturbing thing to watch, it's interesting to note that while Mahmoud Khalil was accused of supporting terrorism, supporting Hamas, supporting Palestinian movements, Ms. Ozturk actually has not. So her op-ed was just asking her university to essentially boycott Israel, to divest investments in Israel. So the grounds that she's being deported on are even shakier than Khalil. So it seems it's kind of like a slippery slope. You know, okay, if you want to claim that one guy was saying stuff that's anti-American, maybe there is some kind of interpretation where that makes sense, but hers seems to be very alarming because when you read her op-ed, she was just saying, "Hey, I don't think the university should be supporting this," which should be, to your point, Mark, a part of the protected speech under the First Amendment. But now she's in an ICE detention center, which are notorious for being really horrible. So that's her arrest.
Yeah, just to follow up on that, First Amendment protections extend to both citizens and non-citizens within the United States. The Constitution refers to the people rather than the citizens, and I want to make that clear. So those protections that we all have enjoyed extend to citizens and non-citizens alike. It's the people who are here in the United States. There have been concerns about potential retaliation against immigrant activists for political speech, which raises huge First Amendment issues. And then the plenary power doctrine limits judicial intervention in immigration matters, creating tensions between immigration enforcement and free speech rights. And I think that's the sort of crux of what we're getting at here. So on both sides of the argument, you have access to legal representation, which has been denied to some of those deemed terror risks that have already been deported. That's talking about the Venezuelan people have been the Venezuelan issue where other people who have a higher status than a green card, actually naturalized citizens, have been deported for past bad acts that have been either forgiven or have been proven in court not to have existed at all. And so advocates are arguing for fair immigration proceedings to happen, full access for everyone across the board to have their day in court before they are deported, just to make sure that they are getting their First Amendment rights as well as other constitutional rights, as we're talking about in the instant case. The government, of course, is saying this is a national security issue. Their emphasis is on enforcing immigration laws and maintaining order, and they're arguing for strict immigration controls to protect against potential threats. Their legal framework is the support for existing legal procedural frameworks, and they're relying on past war acts like the Act of 1798 that I alluded to earlier in our discussions to balance that framework against abrogation of any constitutional rights.
Yeah, that was one of the things I found really shocking on the Venezuelan issue. I saw one individual where there was seemed absolutely no evidence that he had been involved in a gang. He had two tattoos, one with his mother's name and one with his father's name, and both of the tattoos had crowns. So the government claimed that crowns are one of the icons that gang, the particularly vicious Venezuelan gang, I think their name is Tren de Agua. That's one of their symbols, but the government also produced no evidence that this individual had ever been associated with a gang. And his attorney said, well, it seems pretty obvious that the tattoos are that his mother and his father is king and queen. And if the government has any evidence that he's involved in any gang activity, they should have presented it. But the problem is he'd already been deported. So she's trying to fight the case after he's already in a Venezuelan prison without a
Yeah,
crime.
to be clear, without a hearing, deportations are happening, and it would be extremely difficult for him, who had a completely different status than a green card, for him to get back to the United States now. And the whole thing becomes very knotted in where they're being deported, the conditions under which they are being held in the deportation countries that have been identified. It's troubling at best. And historically, case law has established federal government authority in this immigration regulation. That's Chai Lung by versus Freeman in 1875, and a 1977 case, Fialo versus Bell. And then there's the Arizona versus the United States in 2012, which reaffirmed federal preeminence in immigration enforcement. I think those are all sort of playing against the constitutional balance here in favor of the current federal administration's actions. And so it's coming to a head. And with the Supreme Court giving a 5-4 ruling allowing the 1878 law, which was a wartime law last managed during World War II, which again, we look at those, how citizens were treated then, where Japanese Americans were put into internment camps, and uh, people who actually had citizenship were bounced without any hearing at all under a wartime act. I am not aware of us currently being in wartime. However, one of President Trump's very early executive orders was very clear that he feels that we are in an immigration war, and that the status of illegal immigrants, at least as we all understood it at the outset, were the ones that were going to be targeted during his campaign and during the first few days of his administration. Now it seems that it's extending to actual citizens who are doing no more than utilizing their constitutional rights. So there are several implications and impacts here, due process being the first and foremost for me as an attorney. The concerns about the potential erosion of due process rights for migrant workers who we rely on very heavily for crop and other labor type, seasonal labor type positions, which has led to a very odd reinstitution in the state of Florida, where now 14-year-olds who are full-time students enrolled in school, and 14 is typically an early high school freshman in high school, that they can work an overnight shift and then still be going to school the next day. That was a child labor law that was repealed, where 14-year-olds and under would not be allowed to do that. It's just interesting and turbulent times, Ali.
Yeah, definitely. So I see that for Mahmoud Khalil, JuristAI had recommended three motions. I definitely want to talk to some of the erosion of civil liberties. But before we do, Litigates had recommended an action for false imprisonment, an affidavit application for enlargement of time, a motion to dismiss for lack of personal jurisdiction, and it had made some strategic recommendations about the case as well. For Miss Ozturk, it had recommended that she challenges on constitutional grounds, which I assume would be due process because of her civil liberties being violated. It recommended the Administrative Procedure Act. I'm not familiar with that. And it seems like there's some other recommendations here, along with an action for false imprisonment, a motion to dismiss action, and the motion for immediate hearing. So I'd like to get your thoughts on what you think about these recommendations, but just quickly before we do, one thing I found very interesting when I was looking into the Patriot Act, the initial Patriot Act, is that there is a clause in the Patriot Act that allowed the United States government to expand military operations that were not wartime operations, because as we know, war has to actually be sorry,
Declared
yeah,
by
declared
Congress.
by Congress, correct?
Right, correct.
So the executive branch, the president doesn't have sole authority to engage in war, but under that clause in the Patriot Act that allowed the United States to go after the perpetrators of 9/11 and anybody associated with them, what the executive branch has been able to do is say, okay, well, these guys were associated with the guys that are associated with 9/11, and then these guys were associated with the guys who were associated with 9/11. And then they're able to do almost a Kevin Bacon effect where there might be 12 degrees of removal and it's a random person, but now we can justify military operations. So it's
Are you
interesting to see
suggesting
that.
with the Kevin Bacon effect that you're talking about with like the 6 degrees of separation or the 5 degrees
Exactly.
of Kevin Bacon or whatever that is?
Exactly. So I mean, I think it's there's been research on it that everyone on Earth is only about 4 degrees of separation from Kevin Bacon, and
Yeah,
that goes for anybody else. So they've been able to use that to do a lot of what would traditionally be classified as war that Congress would have to pass, but the executive branch is doing it. So now Trump seems to be doing this for immigration purposes. So I'd love to get your thoughts on that and on the recommendations that the AI has made for these two plaintiffs in these immigration cases.
well, to your point, the proposed motions are all relevant, certainly. The question would be the applicability, and I think what the software platform has been able to do is pull up those reasonable motions in a reasonable time that a reasonable attorney could argue utilizing the INA, which is the Immigration and Nationality Act. And so all of them would be applicable. Whether they'll be heard and whether they'll be successful, that will be the art of the attorney that's managing the motions to ensure that they are best representing their client in court. And I think this tool is very helpful in doing that. It's more than useful, I think, to help guide an attorney or someone who's a pro se litigant to an outcome potential that they could argue successfully. And that's sort of hedging a bit because of the current state of the federal courts, Ali.
which is extremely unfortunate to say the least. So here, Litigates has made some citation recommendations for Khalil's action for false imprisonment. It recommended, so these are actually real citations. If you click on one of these, it will take you to the actual opinion so you can read it. We have taken a lot of pains to ensure that any citation our software gives you is not coming from AI. It's a real relevant citation, and the research is very high quality. So this is a case under the Immigration Nationality Act. This is a case for non-citizens awaiting deportation. And again, you can click any one of these and read the opinions. So we will go ahead and click this to get our generated motion with all of these citations. Let's add them all in there. So sorry to cut you off, Mark. I know that you're just
No,
about to.
not at all. That's fine. I think this was that was a perfect place to insert what the software is able to do, show that this is not hallucinating in any ways like some of the wrappers that are utilizing ChatGPT. This is actually, again, connected to Pacer so that there are research tools that are actually relevant and pulling up actual cases that someone who is a lawyer can look at, determine whether and to what extent they apply to their instant case, and the same for pro se litigants as well.
Yes. So here we have action for false imprisonment that the software, it took about 5 minutes to draft this. So obviously we are not representing you. This is not legal advice, but it is a good initial draft for your attorney of record or for yourself if you're a pro se litigant. If I can get Word to open it up.
And just a
So
caveat, because we've run into this with some questions that we've gotten on the platform, Ali. Some of the federal courts are suggesting by order, and when I say suggesting, I mean it's very likely that it's arguable that they are suggesting that there are certain tools that utilize AI that are okay to be used in the court. To be clear, we are connected to the federal PACER database, and the recommendations on the motions are coming from federal practice and its best practices. AI is helping us craft the motion, but we are actually connected to a federal court system that provides accurate and detailed accounts of motion practice as well as the cases that Ali was just presenting.
yeah, that's extremely important. Even if you were to use some research tools that are very well known, that are legal research tools, a lot of times there is propensity to hallucinate. We don't have that because we actually don't use AI to do any of the research. To Mark's point, we connect directly to Pacer, to the federal database. All of these case citations are real. Not only are they real, you can click the link and open it up and look at the opinion yourself. So Mark and I and the rest of the team have taken great pains to ensure as much accuracy as possible. You can see here that we don't let AI put any citations. We will recommend where you might want to put one of these citations, but we want to make sure that when you get something out of the software, yes, it's the due diligence of the attorney or the pro se litigant to take a look at it, but you're not going to get anything that is totally inaccurate out of the software. So just taking a look at this imperative of scrutinizing the foreign policy determination, legal standard authorities, application of facts, counter arguments and rebuttals, the need for immediate extensive relief, conclusion of argument, preliminary injunction, with legal standards, conclusion argument, extensive discovery, asking to pursue discovery, uh, prayer for relief, and then the citations. Is this, according to your experience, Mark, what a motion like this should look like, how it should be structured, and would something like this, after it's been edited and polished up, be something that you could see an attorney filing in court?
Yeah, it definitely is. One of the things that I wanted to mention with the advent under the American Bar Association, some states are looking at unbundled services, Ali, where even if you are pro se and you have the availability of tools like JuristAI's suite of tools for both criminal practice, FedCrim AI, and in this instant case, Litigates, that you can use them with confidence and then either have an attorney help you, which would be very cost effective because you're utilizing this tool, or if you're an attorney yourself, you use this tool as an assistant for you to help prepare for the next stages of your case life cycle.
Yeah, I think a lot of people would have more access to the law if they had unbundled services with a tool like this, where they can kind of go in, they can understand their case, they can take their time, they can look at the docket, they can ask questions to the chatbot, they can prepare interrogatories, they can do all of that, and then also have an attorney to kind of come in and just make sure before they do something big that they have a good grasp on what it is that they're trying to accomplish.
Yeah, absolutely. We'll be following up also to what we typically do after we do one of these presentations for everyone is we'll follow up with a blog post that talks a little bit more about the implications and impact. And then certainly if you have interest, reach out, schedule with either Ali or myself. We'll walk you through the software, show you how it is of great benefit because it's connected to Pacer. If you're using Pacer as an attorney, understand we've got a great interface that allows you to manage your case litigation life cycle and utilize Pacer with some quality recommendations that are coming from our very deep understanding of how federal practice works. And feel free to reach out, schedule with us, get a demo of the software. We'll talk more about this. This is what we do. This is what we like to do. We enjoy it. We want to make sure that you come to us, and we want you to use the platform to your benefit.
So, Mark, before we sign off, where do you think these kinds of cases are going to go under the current administration? And what is the importance of software like FedCrim, like Litig AI, in helping attorneys and pro se defendants navigate this new legal landscape that we find ourselves in?
Having come and being a thought leader in the legal space, Ali, I think you know, and part of the answer of this you've already heard, attorneys are going to have to help people understand that if they don't feel like they can get justice in the typical fashion, hiring an attorney, going through the litigation life cycle with that attorney because it's expensive, it's challenging, whatever the case may be, that unbundled services are probably where we're going to have to go. And that said, tools like this, and especially this tool, will be extremely useful for federal litigants, whether they are criminal cases that they are trying to defend themselves with, or civil litigants who are trying to get um, quality advice at an affordable in an affordable way, and then reach out to an attorney for some advice to make sure that they're on the right track. I think this is a boon for pro se. I think it's a boon for lawyers. It's definitely the way that the future is going to go for legal services. That said, with the current administration, I think understanding these tool sets and having access to these tool sets is going to be key because I think litigation is only going to rise over the next 2 years, certainly, probably over the next four and beyond.
With that, we conclude this episode, we'll be following up with these cases as they develop. It's a huge hot button topic. We really appreciate your time. Please like this, subscribe, share it to anybody else that you think might be interested, and reach out to us on litigai.org or juristai.org. You can contact me, you can contact Mark, and let's have a time to talk. Thank you.
Thank you for your time, everyone.